Who exactly gets to pay a king? It kind of sounds like a plot point from a historical drama, doesn't it? But actually, this very question was the absolute center of a massive constitutional dilemma in South Africa. Think about it. If a traditional leader's financial independence is compromised, can they truly serve their people impartially? This is a fascinating, real-world puzzle about money, power, and the law. Welcome to this explainer. Today, we're unpacking a dense but incredibly fascinating 1996 South African Constitutional Court judgment. Specifically, we're looking at cases CCT 1/96 and 6/96. We are going to explore a really high-stakes legislative tug-of-war between the national and provincial governments over who exactly controls the purse strings of traditional leaders. It's a brilliant look at how newly formed constitutional powers get tested in the highest court. So here is our quick roadmap for today. We'll cover 1. The two disputed bills, 2. The core legal conflict, 3. National versus provincial power, 4. A tax or a consequence, 5. Property and economic rights, and 6. The final court verdict. Let's dive right into Section 1, the two disputed bills. First things first, we need to know who the major players are here. We have the Ingonyama, who is the king of the Zulus and a paramount traditional leader. Then we have the Amakhosi. These are recognized traditional leaders governing tribal communities. Both hold highly revered status. Now, the conflict really ignited back in 1995 when the KwaZulu-Natal provincial legislature introduced two new bills, the Amakhosi Amendment Bill and the Ingonyama Amendment Bill. Basically, these bills sought to regulate the conditions of service and the pay for these traditional leaders. Moving right along to Section 2, the core legal conflict. Now picture this direct clash of the titans. On one side, you have the national law, that's the Remuneration of Traditional Leaders Act of 1995. This national act wanted to pay traditional leaders directly out of the National Revenue Fund. But on the flip side, you have the provincial bills, and they effectively prohibited these exact same leaders from accepting any payment from sources outside the provincial government. So you've got this complete legislative tug-of-war over who gets to fund and, potentially influence these powerful figures. And it all boils down to this really fascinating philosophy highlighted by the court. They noted that traditional leaders can best serve the interests of their people if they are not dependent, or even perceived to be dependent, on political parties or competing levels of government. You just can't serve two masters, right? Avoiding financial dependency on conflicting authorities was absolutely the central theme of this whole dispute. Which brings us to Section 3, national versus provincial power. So what's the legal framework here? Well, it hinges on something called Schedule 6 competencies under the 1993 Constitution. This schedule literally defined the functional areas where provinces had the authority to make laws, and that explicitly included traditional authorities and customary law. Now, the objectors argued, hey, fixing salaries isn't explicitly written in Schedule 6, but the court shot that down. They ruled that if a province has the power to appoint traditional leaders, well, then the power to determine and pay their salaries is entirely incidental and totally necessary to that appointment. But wait, the objectors had another pretty clever constitutional argument up their sleeve: extraterritoriality. They essentially asked, can a province legally enforce a rule that restricts a leader from accepting money from the national government or from other provinces outside of KwaZulu-Natal's own borders? The court's logic on this is honestly quite brilliant. They basically said, no, we aren't extending provincial borders at all. Instead, it's about personal obligations. The condition of office applies personally to the appointee. If you accept the office of an Nkosi under provincial law, you are bound by its conditions, regardless of where you travel. It's literally just an employment condition attached to the person holding the office, the whole shebang. All right, Section 4, a tax or a consequence. So the provincial bills had this strict rule. If a leader did accept outside money in breach of the rules, they had to deposit it into the provincial revenue fund. The objectors completely jumped on this. They argued that forcing leaders to forfeit outside pay to the province was essentially taxation without constitutional backing. Why? Because the province didn't even have the power to impose such a tax. But the court completely dismantled that argument by drawing a very clear line between two concepts. Think about it like an employment contract that bars you from moonlighting for a competitor. The court defined a tax as a compulsory fee applied generally for revenue. But in this case, this wasn't some general fee slapped on everyday citizens. It was a condition of office. The forfeiture was simply a contractual consequence for breaching the terms of a statutory appointment. You aren't being taxed, you're just accounting for funds you acquired in breach of your exclusive role. Makes sense, right? Next up, Section 5, property and economic rights. The objectors really threw the kitchen sink of the bills here, claiming they violated Sections 13, 26, and 28 of the Constitution. They fiercely argued that stopping leaders from earning outside income was a seizure of private possessions, and, on top of that, an unconstitutional restriction on their right to freely engage in economic activity and pursue a livelihood. But once again, the court breaks it down with a super logical, step-by-step approach. Step 1. The traditional leader voluntarily accepts this provincial statutory office. Step 2. That office inherently comes with exclusivity conditions to ensure absolute impartiality. Step 3. Therefore, giving up outside pay isn't a property seizure. It's a known contractual condition. The court basically said that leaders are entirely free to resign and pursue other economic activities anywhere they want. But while they are sitting in this specific office, they have to play by its exclusive rules. Now, what about the royal house? The objectors pointed out that the Ingonyama Bill also applied to members of the royal house, who are defined as immediate dependents of the king. Did this unfairly restrict their private economic rights? Actually, no. The court clarified that the restriction only applies to payments received in their capacity as members of the royal house. It definitely doesn't stop them from going out and getting a private job. It simply means that when they are performing official duties for the king, they must look to the king's provincial funding for support, not go knocking on the doors of other organs of state. And finally, Section 6, the final court verdict. 0. That is exactly the number of constitutional grounds the objectors actually won on in this massive case. Despite the myriad of creative legal angles, from extraterritoriality to secret taxes, all the way to property rights, literally none of them successfully proved that the provincial bills were unconstitutional. Delivering the final verdict, President of the Constitutional Court, Arthur Chaskelson, stated crystal clearly that the amendment bills were not unconstitutional on any of the grounds advanced by the petitioners. The court fully upheld the provincial bills, firmly establishing the province's competence to attach exclusive financial conditions to the traditional leaders it appoints. So, what does this all mean for us? This case leaves us with a huge, profound realization about the very mechanics of government. If absolute financial independence is the key to impartiality, who should fund our most revered institutions to ensure they truly serve the people, rather than just the politicians paying the bills? It's a fundamental question of constitutional law and the delicate balance of power. Thank you so much for joining me on this explainer, and keep questioning how the structures around us are built.